Procedural due process in Philippine labor laws. How to ensure that there is fair treatment in employment termination. Let us define what is procedural due process. Procedural due process ensures that employees are given a fair and just procedure before termination. It requires notice and an opportunity to be heard. What is the legal basis of procedural due process? We have Article 277B of the Labor Code and various Supreme Court rulings emphasizing fair procedure in employee dismissal cases. What are the elements of procedural due process? Number one, we have the notice to explain. Employee is informed of the charges. Number two, an opportunity to be heard. Employee is given a chance to defend himself. Number three, a notice of decision. This is the final decision that is communicated to the employee. Let us discuss now the first requirement, which is the notice to explain. The employer must issue a written notice to explain. This is commonly referred to as an NTE. An NTE should specifically allege offenses and provide reasonable time for the employee to respond. Now, let's discuss about some requirements of jurisprudence about this notice to explain. When you say opportunity to be heard with reference to a notice to explain, you should indicate a reasonable period allowing the employee to explain his side. And according to jurisprudence, this is 5 calendar days. So it's critical and important that the NTE should provide 5 calendar days for the employee to explain his side. Not 24 hours, not 48 hours, not 3 days, but 5 calendar days. That is very important. So if you just indicate a lesser period than 5 days, then that might be a technicality that can be taken against the company. No immediate dismissal is allowed without proper notice. That's basic, no? Let's go to the next slide. Now, second requirement, opportunity to be heard. The employee has the right to respond in writing. The employer may conduct a hearing or conference. Now, let's delve into this requirement of a hearing or a conference. Well, technically speaking, while it is there in most jurisprudence and even the implementing rules of the labor code, this requirement is really not mandatory because the implementing rules, even of the labor code, uses the word may have a conference or a hearing. In my opinion, it is enough that the employee is given the opportunity to fully explain his side, and if his explanation is already sufficient, the employer may already dispense with the requirement of an administrative hearing or conference. But of course, as a matter of practice, especially if you are looking at the imposition of the supreme penalty of termination, I would still recommend having a conference or administrative hearing so that at least the employee is given all and every opportunity, even during the hearing, to explain his side. Now, what about in the administrative hearings? The employee required to bring the presence of counsel? No. The answer is no. The employee may or may not bring counsel to the hearing or conference. That's not a mandatory requirement. So if there is no counsel, that's perfectly fine. third requirement, which is the notice of decision. The employer must issue a written notice of decision stating the reason for termination. Now, with regard to notice of decision, it is really ideal if employers will make this decision as detailed as possible, discuss all the charges, discuss all the evidence that were gathered, and discuss the ruling. It should be as detailed as possible. It should be based on evidence gathered during the process, and the decision must not be arbitrary or capricious. Now, what do you mean by arbitrary and capricious? Sometimes, because sometimes uh, when you issue a decision, you issue it immediately. There is a tendency that that decision is not really uh, well studied or well reviewed. So it, in my opinion, it should be at least allow a reasonable period after the administrative hearing for you to issue the decision. In my opinion, it's at least 2 days will suffice from the date of the administrative hearing. Do not issue the decision immediately after the hearing or on the same day of the administrative. That's that will send a signal that the employee has been prejudged. So it's not a good practice. So at least there's a gap of 2 days from the date of the administrative hearing before you issue a notice of decision. At least that will give the semblance that the evidence has been reviewed and the case has been studied. Now, what are the consequences of violating procedural due process? If procedural due process is not followed, the employer may be required to pay indemnity or damages. The dismissal could be declared illegal, requiring reinstatement and back wages. Employer must ensure full compliance to avoid labor cases. Now, these are the common consequences of a finding of illegal dismissal. Of course, when, for example, there is a violation of due process, but in a particular case there is just cause, then the employer may be penalized with indemnity or damages. Now, if altogether there is no just cause and there is no procedural compliance, then you're going to be at risk with the decision of reinstatement, full back wages, separation pay, and back wages can continue to run until the finality of the decision. And trust me, it can be substantial. So employers must really ensure full compliance to avoid labor risks. Now, what are the key takeaways? Now, of course, we should follow the proper procedures before termination. Always issue written notices and allow employees to explain their side. Give them the opportunity to explain. If they ask for additional period, there's no harm in granting them an additional period. Labor laws protect workers' rights, and failure to comply has legal consequences. Usually, these consequences could be financial exposure and reinstatement. And that will really be an extreme inconvenience on the part of the employer. So thank you very much. Have a nice day.